Yeah. It says it's being live streamed. We're not, are we on? No.
We are.
You'll let us know when we're on, right?
We're on.
Oh.
Good afternoon. We are waiting on one panelist, and we will be joining or starting shortly.
All right, guys, we're about 2 minutes out. Guess we'll wait to see if Sally can get in too real quick. Oh, there she is, I think. Sally Peebles, right?
That's right.
All right, got it.
All right. Right on time, 4:20. Welcome, everybody.
Hold on a second. Let's let her get in here. Just a reminder, guys, if you aren't speaking, go ahead and mute your mics and unmute when you're ready to talk. That way you don't pop up if we're in a speaker view kind of setting. And let me get recording. All right, you're live.
Welcome, everybody. My name is Daniel Sparks. I'll be the moderator for the panel today, and we're going to be talking about predictions for 2024. For those of you joining us for the first time, the Cannabis Lab is the association in the state of Florida for attorneys and accountants and business people, MMTCs, ancillary businesses, and individuals that are interested in getting involved in the cannabis industry and helping to push it forward. So thank you for joining us today. I'm joined by my esteemed colleagues and friends. We have a star-studded panel today of Florida attorneys. If they'd like to just give a quick little intro about themselves, just a brief, introduction to the group, and then we'll get started on our predictions for what seems to be an action-packed year in 2024, both in our home state of Florida and on the national level. So Sally Peebles with Vicente, please.
Hey everyone, I'm Sally Peebles. I'm an attorney and focuses on cannabis and psychedelics. My law firm is a national cannabis psychedelic law firm, and we've been doing this a real long time. We do a lot of policy work, and we're the ones that legalize marijuana in Colorado and just legalize psychedelics at the state level too. So hopefully we'll be doing the same here in Florida soon. So thanks for having me.
Absolutely. Gary Kaminsky.
Hi, thanks for having me as well. I really appreciate the opportunity to share. I am a lifelong legal regulatory attorney, used to be an SEC enforcement attorney, and went from busting people for insider trading and running hedge funds to navigating cannabis regulatory issues across the country. Been doing that for about 10 years now for both marijuana and hemp folks, and also work a lot with the American Trade Association for Cannabis and Hemp, which is a 501(c)(4), which has a lot to do with what's going on in both Washington and among the regulators. So excited to hear about what's going to happen.
Thank you. And Matthew Ginder.
Hello, my name is Matt. I am an attorney with Greenspoon Marder. I'm based down here in South Florida. I practice in cannabis space and hemp space. Looking forward to this discussion. I think 2024 is going to prove to be a very eventful year.
Agreed. And what my very humble colleagues and friends are not sharing is that they're all really at the tip of the spear, and they all have really contributed to the growth of the Florida program and really expansion of cannabis law reform on a national level, which we'll get into a little bit later in the discussion. I'd like to start our discussion on the state of Florida, our home state, We're all present here in Florida. There have been a number of bills filed in this legislative session that's going on right now. Some of them more forward thinking than others. Some of them, may have been introduced for one reason or another, and I'd really like to get into kind of listing those, and then talking about what the potential implications for these bills, these changing bills, could potentially be for our state. So, starting with, I guess, the most recent action in committee for this one particular bill, is the location of medical marijuana treatment centers, particularly for dispensing facilities. This bill also has distance separation requirements for retail vape shops and on-premise consumption of alcohol. So quite the bucket of potential changes with this bill. Really, this is going to be an open discussion, right? I definitely want everybody to contribute, but anybody that wants to chime in and to talk about this particular bill and the potential ramifications. Sally, thank you.
Well, I feel like this one's kind of going under the radar. I don't believe it has a Senate bill, a companion bill to it, unless I've missed something. So maybe people aren't concerned about it for that reason. But it's going to have far-reaching effects for a lot of my clients who just applied, because it doesn't go retroactive. It is going to apply for anyone operational after July 1st of this year, which is basically all the new applicants. And it's pretty draconian. It takes it expands that setback to 1,500 feet, and it slips in religious institutions. So it's doing what we saw in many of the early states. We had this in Colorado. We had this in a lot of the original states that decided to regulate cannabis. And when Florida made that decision not to add churches and had that separation between church and state, I was actually very proud to be from Florida. I really thought that was very forward thinking of them. And so I'm disappointed to see that here. It also adds daycares, and it adds colleges. So it's really going to make it difficult for companies to find a dispensary. I wouldn't say, compared to some places in other states, that we are overrun by dispensaries. I mean, I live in an area that we have one anywhere near us, so I'm sure there are areas of the state that have higher. But we're certainly not in a situation where we saw in Denver, where everyone kind of wanted to pump the brakes a little bit and create some bigger setbacks. And so I am disappointed. I'm hoping that this doesn't continue pushing forward.
Yeah, agreed. And really, in a lot of places, that would result in a ban, effectively, where you have to be that far away from all of those uses. It would by default become a ban for further retail in certain locations and municipalities. Matt, I think you want to chime in. Go ahead.
Yeah, absolutely. This is, the distance separation requirements, of 1,500 feet. And then from all of these facilities, I mean, right now it's K through 12. I mean, this expands it to daycare facilities, religious institutions, schools, post-secondary, colleges, universities, trade schools. I mean, it's going to be hard pressed, especially in, populated areas, to find locations. And I think this affects not only the applicants, but some of the newer license holders that are still yet to expand their footprint, their retail footprint throughout the state. So, this is, as Sally mentioned, this was one of the ones that was under the radar, but I watched the committee hearing, which was yesterday, and it passed unanimously out of its first committee. So it's something to keep an eye on. I really wasn't paying attention to it until, just recently.
It also takes away the local jurisdiction's ability to grant a variance, I believe, which we saw in the original statute, which was also a breath of fresh air. And it specifically for dispensaries was allowed to get a variance, which usually in other states you only see variances allowed for the cultivations and the processing. So definitely a worrisome thing, and something, if you're out there and you're an attorney, I would definitely tell your clients to watch this carefully.
Absolutely. Gary, do you want to opine on this prospective bill?
I haven't really focused that much on it, but I would say that, I live in a very populated area in Coconut Grove, Miami, and there are a number of dispensaries around me. But even yesterday, because of a choice, I had to drive to South Beach to go to Jungle Boys because that was the only place that had decent flower. So I'm all in favor of more dispensaries.
I mean, this even takes it a step further and includes vape shops. So if you're looking to open up a new vape shop, these distance separation requirements would apply as well. And that would,
Well, that actually is interesting because I also, well, we all do if we live in Florida. There's a smoke shop on every corner. There's some corners that have multiple smoke shops, and if they're gonna, I don't know what they're going to do in that regard, and in terms of who has to close, but or how, or if they're just not going to open new ones. I just
Yeah.
hope they've thought through that.
The latter, it seems, but this is all perspective. The strike through, the strike all, I believe it was, in relation to whether or not a municipality could issue a variance came after the original version of this bill. So they're doubling down, if anything, making it even more restrictive than originally introduced.
And I'll add this post-secondary, that has been that it's included in Denver's, and that has been such a nightmare for my clients. And my husband owned a dispensary in Colorado, and just from personal experience, we tried to move our location, and because there was, it was it really depends on how they define post-secondary, but it was someplace that had once a month IT classes, that allowed IT certificates. They considered that post-secondary. It wasn't, just any college. So that really, it was so difficult to find any location specifically because of the post-secondary.
Yeah, and considering the fact that college students are adults and have medical marijuana cards accordingly, I don't really see the issue as far as particularly for colleges, and there's colleges all over the state, so it would amount to just more restrictions. Have to wait and see as far as that one. Moving right down to what I view as a preemptive strike, and definitely something that kind of will bring up a broader topic that we're going to talk about, is House Bill 1269, which is a restriction on the potency for adult use marijuana products. Of course, the current program is a medical marijuana program. We have a ballot initiative that is pending Supreme Court review to be on the ballot. And this bill was filed in anticipation of the possibility of adult use. And the fact that it was filed by Representative Masulo, who is a medical doctor, is a thing, right? I don't know to what degree that how much weight that will hold for this, and how many the legs that this has or doesn't have. But yeah, curious to hear what you guys think about this bill.
I can jump in. I didn't know if
Sure.
Matt was going to go.
Yeah, no, go ahead.
Everyone had unmute, so I didn't know if
Yeah.
Ladies first, I guess. Well, we've seen this in the past, and it never moved forward, so I'm hopeful it won't again. I think it's the last dying, attempt for reefer madness. I'm not as concerned about it coming from a medical professional, especially in light of the HHS, having hundreds of pages saying this does have medical efficacy and safety. I think that there's enough federal and state guidance showing that, cannabis has never had an overdose. The DEA's own statistics that just were published shows there's never been a single overdose for cannabis. So I'm not as concerned anymore. And in fact, I'm feeling very strong that it will get defeated. We just need to make sure that those who feel they will be affected do submit comments for something like this. And if they have a lobbyist, get their lobbyist on board for this to educate.
Agreed.
Yeah. I mean, this is a good indication that, you know, the folks up there in Tallahassee think adult use passage is a real prospect. So I think there's good news there that they're thinking ahead. The bad news is, you know, we're seeing where they're, you know, certain folks and congressmen's heads are at with adult use, and, you know, what they're, you know, that they're not necessarily looking to you know, invited into the state. They're going to take steps to you know, restrict it. It should have passed. So this is you know, the limits in here are something that, you know, we can discuss and have, you know, legitimate debates about. Obviously, you know, I think these, especially with the THC potency on flower at 10%, I mean, that's you know, that's a poison pill. But you know, I think it's interesting to see, you know, if there's going to be some debates about adult use and, you know, how this all fits in with the prospect of the Supreme Court approving it and getting on the ballot. So it should be interesting that conversation starting in the legislature.
Definitely seems like forecasting, hopefully. Moving down my list, again, this is in order of recent action, most recent action. Senate Bill 1300. And this is a bill that effectively is a cleanup bill for the telehealth amendment that passed, and the telehealth bill that passed last session. And the amendment to the telehealth bill, the intention behind it was to rectify and to clarify the Pigford class and the Pigford class of applicants in Florida. So Senate Bill 1300, filed by Senator Davis, further clarifies, if you will, and provides relief to specific applicants that arguably, and in my personal opinion, you know, should be granted licenses, assuming that they are qualified and meet all the qualifications. They most definitely should be issued licenses. So, Gary or anybody, if you'd like to talk about this one, we can talk about it. And if not,
thank you. This one is something that I'm very close with. I happen to be part of the team that had the highest score in the Pigford round, and we have been denied our license. And frankly, Senator Davis has been gracious enough to introduce this legislation, which she's calling glitch legislation, because somehow or another last year, when the legislation was presented that she had seen and approved, before it got finally approved, they changed the language on her, and somebody made this death date a different date than it should have been. So if you look at this legislation, it clearly says that its mandate is to provide that the death of a certain applicant does not bar the estate of such applicant from challenging the department's decision on the application, and it may not be a reason for delaying denying any challenge. And that's the way this was supposed to have been written last year. It's the logical way to have it. These Pigford farmers are extremely old. The state took a very long time to get this done. It took them over 7 years from when they were supposed to. And these are folks who were already in their late 80s. So the fact that some of them may pass is not a surprise, but I do believe that this glitch legislation has pretty strong support, and we're hopeful that they will rectify this, and hopefully the Department of Health will then be forced to do what they should have done last year.
Agreed. I remember when SB 8A was being drafted and the Pigford language that was inserted in SB 8A. And passed in special session. We can move on to the topic of hemp, if we'd like. House Bill 1613. Gary Kaminsky, take it away.
Well, this one also, I'm very active in the hemp business, and on the legislation that have been promulgated across the country. I've interfaced with CANRA a lot, which is the regulatory bodies on this. And we're seeing a lot of different hemp legislation, at least being bantied about across the country. Florida is the most recent. This was tried last year. It appears to be a transparent push by possibly the marijuana side of the industry. We don't know. But what it would do, if it were passed, would dramatically change what's going on in the state of Florida. I think that the webinar we were on, Daniel, I don't know, 3 months ago, you had a business guy on who guesstimated the size of the hemp business in Florida alone. And that was a multi-billion-dollar business. And what this legislation purports to do is to basically gut all of these smoke shops from selling any products that resemble intoxicants. And it does not seem to me to be perfectly written in any way. The most important thing with hemp, which I think everyone agrees, is that they've dealt with last year, and that is public safety. They dealt with testing. They dealt with age gating, which is very important. This statute amplifies products that are not to be attractive to children. It should not be sold to anybody under 21. And we should know what's in the product, so there should be good labels on these products. That is all important. My view is when it comes to the question of intoxicant, we don't prevent people from drinking Everclear as opposed to some sort of seltzer. That's a personal choice for adults, and I believe that that's how it should be. The other problem that they're going to have with this bill is that we don't know exactly what's going to happen with the Farm Bill. And at current, this bill is certainly in conflict with the Farm Bill and potentially unconstitutional, similar to other bills like in Arkansas and some other states where they have tried to come up with bills that would override the Farm Bill's provisions concerning the definition of what hemp is. So they come up with a new definition of hemp extract that wipes out all Delta-8, Delta-10, a lot of the synthesized cannabinoids, but they still make the mistake of assuming that because a cannabinoid is synthetically processed, that somehow there's a problem with it. The problem isn't the process, the problem is how it's processed. The problem isn't that it's processed. There's a big difference, in my opinion, between a synthesized cannabinoid and a synthetic cannabinoid. See, THCO is a synthetic cannabinoid. It didn't exist in nature, so we don't even know what it is. But using good manufacturing processes to take cannabinoids and create other cannabinoids isn't necessarily problematic. But unfortunately, I don't think that across this country, the legislators or the regulators have taken the time to understand this completely when they're drafting it. So, this provision would be dramatic. It also addresses events. And I don't know about you guys, but my farmer's market sells these products here in Coconut Grove. And it's very prevalent. There's trucks running around this Miami selling these products. So I would just, and this is something that Matt and I were talking about, I would just recommend that if they do go this far, that they put enough money in resources for enforcement, because to create a bill that no one's going to enforce is going to create incredible confusion and disruption in a very large industry. And I don't think this is a well-intentioned piece of legislation.
Yeah, I agree with Gary, and I would add just a few points. First, Florida has been a very hemp-friendly business environment. So there have been companies that have moved from out of state and relocated to Florida to operate their hemp businesses down here. And, this bill, as in its current form, would have significant negative implications to, the hemp derived product market here in Florida. And, we saw the first committee hearing, there were a lot of public comments that were addressing those implications. This still has a long ways to go. They tried this last session and passing a restrictive bill for hemp products. They were able to, come to some sort of compromise that didn't implicate the products or the type of products that were permitted to being sold here. Here's another attempt. And, we'll see. This is something you have to take very seriously. We'll see, how this bill progresses, but there are significant implications to the Florida market for this bill.
One thing I would add is that, because there was a bill passed last year, and that bill definitely covered testing and labeling and age gating, which was very important. This one clarifies that it applies to the manufacturers. Believe it or not, they didn't say that last year. They just said it couldn't be distributed, which left the question of, well, who's going to take the fall for it? So all I would say is that there are any of these manufacturers listening who Matt had referenced, for instance, that were coming into the state and have now set up camp. This is an important bill to get your lobbyist or whomever to focus on.
Sally? No.
Yep, I've got clients on both sides. I'm sure we all do. And I understand the arguments from both sides. I'm an attorney, so when it comes to this issue, I'm trying to stay in the middle. I do wish that there was more clarity for my clients. As you guys mentioned, clients coming into Florida because the hemp was so open-armed, and Nikki created such a supportive, very easy, navigable program. We're in all 50 states, my firm is, and the hemp team is like, I wish back when Nikki was still in charge, like I wish all states could be like that. The website was so easy, everything was at your fingertips. So it's frustrating to see them dialing it back. But, from a practice point of view, I just wish there was more clarity. I wish that the FDACs would come out with some more policy statements. And I know that in some ways their hands are tied. But I'm not as concerned that this will get passed. I think that most people I'm talking to are throwing a lot of money to fight it. We'll see.
One of the areas I didn't mention, which it may be pretty obvious to us, but is that this bill would also stop the practice of selling THCA flower in smoke shops and in farmers markets, etc., because it imposes a total THC test as opposed to the Farm Bill 0.3% test at retail. So I know that Rod Kite with a group of folks were meeting with FDACs last week, I believe, on the THCA flower subject. But to me, that's a kind of a little bit of a separate discussion on whether that is an appropriate use of the Farm Bill to sell basically weed. So that's a separate issue. But this bill would stop that practice as well.
And this is what Florida's going through now. I know Gary touched upon this, but you're seeing this in states throughout the country where, the lack of federal action in the legislature is causing states to address this, either by regulating it and or prohibiting it in one way or another. And, after, a bill passes that's negatively implicates the industry, you see stakeholders filing lawsuits in that state and trying to strike down the law. And then we're left with, in certain states, sort of a legal limbo, as to whether certain products are legal. So that's a potential here in Florida. If this does get traction and it's very restrictive, that is a path I can see happening here in Florida.
I think we had a pretty comprehensive overview of the different bills in the legislature right now in Florida. And I'd like to move it over to the judicial branch and just kind of further expand on where we are with the Smart and Safe initiative and what the prospective timeline is, ramifications, that sort of thing, for adult use in Florida. So whoever wants to lead that charge, go for it.
Happy to kick it off. So our last webinar talked about oral arguments and sort of what the prospects were of the ballot initiative being approved by the Florida Supreme Court. We were cautiously optimistic after hearing oral arguments. I think that was the consensus of the panel. I think we have more reason to be optimistic now, especially since Governor DeSantis, was it last week or a few days ago, came out and it was reported that he believes it will be on the ballot. And you got to believe that his insight is coming from his, the state's attorney general, who's opposing it. So, I think that was definitely very good news to hear where the governor's thoughts were on the prospect of this. And I think that definitely from my internal probability calculator, it's increased. But from a deadline perspective, the Florida Supreme Court has until April 1st. So we're only looking at a couple months to find out whether this will be on November's ballot. So that could happen tomorrow. Or by April 1st. So let's keep an eye out for that.
I have spent 10 years practicing in a state that Colorado and Oregon as well that has full legalized marijuana. So I'm bullish on the issue. I have had a bit of a culture shock when I moved to Florida, back home to Florida 6 years ago. It's a very different industry. It's a little more warm and welcoming out west. There's a sense of freedom in it, and I'm just thrilled to see that my home state will be hopefully taking this step and at least allowing the voters to decide whether or not they want reasonable drug laws in place. And we should be regulating like this, like alcohol. Prohibition should end. So I do hope that it makes the ballot. I hope that voters come out in droves to support it. I know that recently there was some poll that said that we wouldn't make the 60%. I live in one of the most Republican areas, I think, in the state of Florida. I'm in Jacksonville. I don't think I know a single Democrat in my neighborhood. Very different from living in Denver, where it was the opposite. And every single person I know is supporting it, and they're all Republicans. So I think those polls are not showing the truth, the true desire to really put an end to cannabis prohibition.
Well said. And I definitely feel and believe that this is a nonpartisan issue, right? It's not a red or a blue issue. It's a people issue, right? And like you said, well said, expand, a much needed expansion of our medical rights, our personal rights in general. So
yeah. And I think when people often I still have discussions like I'm for medical, but I'm not for adult use. And I think what's lost in that is that most patients, most people who truly need marijuana, they're not interested in going to talk to a physician and getting a physician recommendation and putting their name on some list or having that awkward conversation with a doctor. That would be a really heavy lift for most people. I'm surprised we have 900,000 patients. I mean, that's a pretty bold move for those patients. But I mean, if you're truly sick and you have anxiety, an anxious person is not going to talk to a doctor about this. So I think when you open it up to adult use, you're not just opening it up to recreational use is what that's a misnomer. You're opening it up to mainly patients who just didn't want to take that step. And so, it's still medical. Even if you're using it to relax, that's still medical. So.
Great point. Definitely agree with that. All right. So lots of action in the legislature. The potential for adult use is hopefully going to be a greater possibility here very soon. I think we all, well, I'll speak for myself. I'll definitely be, in support of getting people to turn out to vote for that. And, we've seen a number of elections where cannabis and votes for expansion of cannabis laws receives more votes than any candidates on ballots. Looking at Ohio and what we recently just saw them pass adult use, even though they're trying to peel it back now, the fact that that issue was on the ballot not forced people, but encouraged people. People turned out to vote. So this is a presidential election year, as we all know. Our governor is no longer in the race, and he's going to get back to governing the great state of Florida. And I think it's actually great that one of the first comments that he made after shutting down his presidential campaign is that adult use will likely be on the ballot, or it will be approved by the Supreme Court. So he's clearly got his priorities in line.
Well, let's not get carried away, but
Well, just embellishing a little. Regardless, I guess we've spoke about the legislative. We spoke about the Supreme Court in Florida, and moving over to the governor's office, as we were just talking about, and the Department of Health, which is part of the governor's office, or under the purview of the governor. We are in a current licensing application round in Florida, and 73 applications were received by the OMMU in April of last year. And Chris Kimball, the director of the OMMU, spoke in front of a Senate committee in November, I believe it was, and he was questioned regarding licensing. No surprise that Senator Davis filed the bill, SB 1300. This is specifically the line of questioning that she had for Director Kimball during that committee. And Director Kimball told us that the Pigford licenses hold precedent and are first in line to be issued licenses per the telehealth amendment. And if this bill passes, the session ends in March. It goes into effect.
immediately.
Okay, so that's potential timeline. If it goes into effect immediately and it's signed a couple weeks after the end of session, presumably, hypothetically, there should be additional Pigford licenses issued as a result, if not in March or after session. I guess I'm stumbling over the potential timeline for additional licenses, which I think is an area of interest for everybody on the call, and most definitely everybody that's listening as well in some way, shape, or form. So yeah, to whatever degree we can talk about that. Curious as to your thoughts about this licensing round and what we can potentially anticipate.
Well, I mean, I would think that if you're referring to the 70 plus applicants that, when those will be issued, he made the comment 6 months. I don't think, I think if you look at how that was answered, it was more like he was being pressed.
Yeah.
It's like 6 months, a year, what, and he said, I think we get it done in 6 months. I think we definitely will not see it before the legislature concludes. So sometime after that. So I mean, we are on a predictions, right? So I'm predicting May-ish, but I'm hopeful. I mean, it took them 9 months to do 11 applications. Is that right? So it's going to take it's going to take over a year or so to do 73. If they could get it done in a year, that would be impressive. And I do hope they take special care with these, because I would hate to see, I wish there was something that could be passed during the legislative session that would quiet the challenges somehow. I'm not sure how that would be possible, but that would just be wonderful, because I think it's such a shame that people apply and then are given licenses and then there's a bunch of litigation after that.
I think we can definitely anticipate that part in this next round.
Or I just wish the litigation didn't stay the final issuance. I think everyone has a right to sue if they feel wronged. It's just, it shouldn't delay everybody else from operating. Because you're only the patients are being hurt there, and then it's so expensive, and you're really deterring people from applying in the future. You're deterring educated people from applying for something if they know they're not going to get operational within years. That's just not a good investment. And you want good operators, to be
interesting because
incentivized.
This is you're absolutely right, Sally. And this is an issue that, as you well know, has been prevalent all over the country. I mean, New York, every week, it seems like, makes a misstep that leads to litigation in their process. And a lot, I had hope when they created CANRA that CANRA would, bring together the 43 regulators and that they would start normalizing the challenges of is a very challenging business. And I think that Gillian, who runs that, is doing a great job of trying to pull that together. But this is a good example of where, you're not learning from other states' experiences lead you down the same path to litigation. And I can tell you from first being very actively involved in litigation for the last year and a half with the Department of Health, sometimes it doesn't even feel like litigation because you're in their own court and they do whatever they want. And they're kind of, what's motivating them is very hard to tell, because it certainly doesn't seem like it's in the best interest of the state of Florida to prolong litigation.
I think they're bringing it on themselves. They made that policy decision at the beginning to be the ones to say, you get a license and you get a license. That is the policy decision that these states are making, and they know they will get sued and they know it will be expensive, and they still do it. Why not just open it up?
What you mean, open it up to just be a lottery like they did in New York?
No, open it up like Colorado or Oregon or Mississippi just did, how Kentucky is about to do it. You go background check, you go to facility, you still have setbacks, you can still local jurisdiction to limit it, but you don't have the state limiting the numbers of license and creating a merit-based application where people are paying people, that causes the litigation.
Well, that does. The challenge there, and Florida, unfortunately, whoever was on the other side lost this. Unfortunately for the people who won, the vertical nature of the license and the fact that you can open up an unlimited number of dispensaries makes what you just described almost impossible, because you just can't be giving out an unlimited number of licenses and have like thousands of dispensaries. And given the law that you guys opened with, that's going to make it even harder to open it. Well, these are inconsistent things. And I think that, it's very hard. I just would like to see administrative procedure followed in an appropriate way. That would be a starting point.
The interplay between state and local government is definitely going to be at issue moving forward in Florida and elsewhere, and we can look to an example like California, where they give total control to the municipalities, and it has resulted in one of the biggest cannabis, consumer markets, definitely in our country, if not the biggest, being hamstrung by, arguably NIMBYism of cities and counties saying, well, yeah, we want adult use, but we don't want a dispensary in our entire county or city. And that can be, it can choke an industry to the point of, again, what we're seeing in California right now, which is flight, frankly. So
What was that word, Daniel? Just what is NIMBYism?
not in my backyard.
Thank you. I'm old. Okay. Did you know that, Mark?
Gary, that's a pretty old term.
Yeah, it's older than me. It's older than
Well,
me.
he had it in Gary's
I'm
defense.
just,
You added the
clueless,
ism at the end.
I'm not
Sorry.
sure you get away with that, be it saying
you.
you're
Thank you, Sally. If three of the four panelists are familiar with the term, we're just going to go ahead and it's an accepted
I'm just messing
acronym.
with you. I'm just messing with you, Gary.
Appreciate that.
I'm very messable.
So I think that we've really covered what's happening in Florida from a pretty broad and also dialed in perspective and scope. On the national level, of course, I think the biggest topic of discussion is the potential for rescheduling into Schedule 3. And Sally, by your enthusiasm, I'm honored. I'm happy to let you take over this discussion and to tell us all about the potential ramifications for really what is possibly one of the biggest developments in our space ever. So,
Absolutely. So, I mean, I'm probably preaching to the choir here, but this in the last 100 years, this is the biggest news in cannabis. And, as we know, HHS has made the recommendation to move at the federal level cannabis from Schedule 1 to Schedule 3. And we are thrilled to see this news. Finally, we have a government agency recognizing the medical efficacy and safety, saying that there's a low potential for abuse. But I just want to have a bit of a call to arms for everyone on this call and my fellow panelists. There is still a lot of work to be done. And I think that there is this idea that this is just going to happen, that the DEA is just going to issue the rule and we're all going to move on and benefit from that. But we need to keep in mind there is opposition, and they are very organized and they are mobilized and they will fight this. And it doesn't have to, even if the DEA issues a rule, it doesn't have to go our way. So what can we do? First, we need to be knowledgeable on the process here. So the next steps, HHS has submitted their recommendation to DEA. DEA, this is binding on them. They have never ignored an HHS recommendation in the past, so we do believe they will initiate rulemaking and say that they are announcing that they approve this. They could skip that, but we do anticipate them initiating rulemaking, and there will be a 60-day public comment period. We need, as an industry, as stakeholders, as in the scientific community and the research community, we need to organize and submit those comments. I plead with any of you on this phone, on this call, you get on your next email when you close your computer, is to ask everyone to write comments, reach out to their contacts. They can submit comments directly, and they can reach out to me. We have a lady in our firm, Sean Hauser. She's amazing. She's been working on this rescheduling issue with the Coalition for the Cannabis Rescheduling Reform and not doing much else and not really getting paid for it either. She is going to be organizing these comments with the coalition and submitting them in an organized fashion. And that will be part of the administrative record. There will be a hearing. After the DEA spends a very long time reviewing all of these comments, they will issue a final rule. And then the key here is there will be 30 days before that rule becomes effective. During those 30 days, guess what? You can file a challenge. Sounds a lot like Florida, right? You have a 30-day time period and I guarantee it, challenges will be filed. And the other side is already mobilizing. They are well-funded and they will sue. And so our side needs to be well-financed as well. So the coalition is going to hire an attorney. We hope to hire the best. My firm doesn't do that sort of litigation, so this isn't a call to pay me, but we do need the funds to pay an excellent litigation attorney who can focus on this, a constitutional attorney. And if you are interested in helping, please reach out to me directly. You can submit comments. You can help us finance this fight. And I can put you in touch with the right people. And I just wanted to take this moment while we have some to educate you guys, and please, other panelists, please educate your contacts as well.
Thank you, Sally, and definitely we'll follow up with you on that, and we'll talk further about how we can make sure that message is spread far and wide, and we get everybody to contribute, because really, you know, this is our industry, right? Everybody on this panel, everybody on this call, like, again, I meant what I said. We built this, and we are flying the plane as it's flying, or we're building the plane as it's flying, so to speak. And this would be a major step in the right direction, in my opinion.
I mean, every call I've had in 10 years, half of that call, and if it's an investor, all of that call is spent discussing 280E. And if the DEA issues this final rule in our favor, it will get rid of 280E. 280E only applies to Schedule 1 and 2. So, I mean, as I said, my husband owned a marijuana company. That was that I personally have felt the pain there. And we're also talking about opening up capital to the industry. We're talking about the broad implications for federal policy related to immigration, gun laws, military eligibility, housing, employment. I mean, it's going to touch everything. So I plead with you guys, instead of people sitting back and complaining about the industry and like just expecting someone else to take care of this issue for us, we are lined up and ready to do it. We just need some help. We need those comments, and we would need some funding. Thanks for your help.
Absolutely. So we have about 10 minutes left, and I'd like to open it up to the attendees to ask any questions if you'd like. Happy to.
Yeah, just type your questions down in the Q&A down in your toolbar on your Zoom window.
And if nobody has any pressing questions, I'd like to turn it back to the panel to any final thoughts, predictions, comments, questions, concerns, things they want to talk about.
Yeah, I mean, I'll take a crack at that. I think that what I'm really involved with, and several years ago, I'd say 4 or 5 years ago at Attach, we started to see the conflation of marijuana and hemp, because they're both cannabis sativa L. It's an arbitrary test that decides whether you're hemp or marijuana. And it's interesting because over the last year, there have been some rumblings of a civil war, so to speak, between hemp and marijuana. And some of it's been fueled by some of the articles my buddy Rod has written, which has been critical of CANRA and critical of Attach, the organization I'm involved with. But also some of it is because of the marijuana business side of things, I think, fueling a fire. But the reality is, since Sally was making a plea, my plea is that we come together, because this is a cannabis industry, and cannabis is marijuana and hemp. There's only one flower, there's only one plant, there's only however many cannabinoids, and as long as they're not synthesized, they're the same. And I believe that it doesn't do an industry that has been in prohibition for many, many years, and still has plenty of people that would like to put it back there, to be fighting among themselves about things like, well, they can sell intoxicating materials, but we can't. That is one of the worst things that a marijuana person should ever try to argue to anybody, that there's something wrong with intoxicants. Point in fact, and I just saw this on the news today, if anybody saw this, is that there is actually a judge in the United States that let a woman off from stabbing her boyfriend 100 times because she claimed she was stoned and she had a psychotic reaction. And this judge bought off on that. And this woman, it's in the news, you'll see it, got off. And that is not a good thing for our industry, because I have been, let's just say, inebriated on strong levels on THC, and never have had or seen anyone who's had a reaction like that. So for a judge to not only accept that defense, but then to sentence this woman to probation and never send her to prison, tells me that there is still dangers in our industry. And education is very important, and normalization of regulations. And with the Farm Bill coming up for amendment, I think we have to keep that in mind. But I also think that these state regulations and legislations that come in, they need to start understanding what they're legislating and regulating.
Can't argue with that. As much as, you know, we can sit here and talk about the history and the timeline, you know, the analogy of what inning are we in, you know, I don't even think the game has started yet. I mean, if we're in the first inning, you know, I think that that's generous. You know, we have no interstate commerce. We have, you know, hemp and cannabis kind of at war with each other right now. And there's a lot in the air. There's a lot up in the air as far as all of the things that we've talked about today and some. So we still have a couple minutes here. I don't want to cut anything short. Eric Rogers, thank you for your questions in regards to Eric asked the bill number for the distance separation requirements, which is HB 1053. If anybody else has any questions, you're welcome to ask them here, or you can contact any of us. I didn't really intro myself, so maybe I'll outro. Oh, here we have a question here. Cannabis versus hemp dispensary. Isn't the argument cost to open and other regulatory compliance? If that argument is accurate, and if CBD stores are selling high THC products, why shouldn't that be regulated? I'll take a stab. I don't think that cannabis, hemp, CBD, all cannabinoids, right? I don't think anybody's arguing that they shouldn't be regulated. However, when there is active legislation that we were discussing earlier that could have a massive impact on a $30 billion industry that Florida, you know, definitely participates in and employs a number of people, particularly, you know, we're talking about the companies that have relocated here on the strength of how the program was originally set up, the hemp program. It would have a very severe impact if these bills were to pass. And as we mentioned, you know, Florida is not the only state that is attempting to restrict hemp and hemp commerce, particularly outside of how the current farm bill has defined it. So all of this is in flux. Hopefully we will see a new farm bill in September that, I mean, I won't speak for an entire industry, but it seems like if there was little to no change to the farm bill, to the 2018 farm bill as it relates to hemp, that would be a positive result. There's all types of opinions on what could potentially happen, or if there could potentially be changes to it. My understanding is that, you know, we're past the 11th hour as it relates to that big of a document that only changes every 4 years. So definitely a lot of things to be determined, right? Almost everything we talked about is pending or to be determined. So I want to thank my panelists, Matt, Gary, and Sally. Thank you to C-Lab for giving us the opportunity to talk to you about what is going to amount to possibly one of the most impactful years in the cannabis industry ever, on a national level and definitely for the state of Florida. So thank you, C-Lab. Thank you to the attendees for joining us. And if you haven't already joined, please go to joinclab.com and you can see the different membership and sponsorship opportunities, and look forward to seeing all of you and hearing from all of you very soon.
Thank you.
Thank you very much.
Thanks, Daniel.
Have a great night.